This is KUTV Primetime News with Irene Mwangi.
Thank you for staying tuned. It is that time for our discussion as we promised, and tonight we are having Mr. Edwin Kigoli, who is a political analyst, to look into the BBI ruling by the 5-judge bench of the High Court. Many thanks indeed, Mr. Edwin Kigoli, for joining us tonight.
Thank you, and many thanks to you, Irene, and our viewers. I'm happy to join you today.
All right, now let's start off looking into the BBI ruling by the 5-judge bench. Some have termed it bold, others they're saying it is politicized. From where you sit, what did you make of that ruling by the 5-judge bench?
That is a landmark ruling, in my opinion, and political analysts and legal experts have agreed to the fact that, this is a ruling of a kind, and I have never seen a judge who would invoke the name of a sitting president in this our country. And when you go through the ruling of the High Court, the 5-judge bench ruled that, of course, the president has contravened Chapter 6 of the Kenyan Constitution, and they were so specific as to which article and sub-article that the president has contravened. And when you look at their ruling about the entirety of BBI process, they say that this is a process that did not follow the due process, like this is a constitutional amendment process that is unconstitutional. And many legal experts agree to the fact that it will somewhat be an uphill task to appeal this decision. And yesterday in one of our TV stations, one of the legal minds was arguing to the fact that a court cannot issue stay orders of a declaration. A court can only stay an action. Say we have directed the IEBC to conduct the by-election. So somebody can go to court and say, we are seeking conservatory orders or stay orders that the IEBC not to proceed with the by-elections. But the legal experts were saying, if the courts are saying, the IEBC is not properly constituted, then that is a declaration. And staying that, is not provided for succinctly in the law. But then again, Irene, when you look at this ruling, the judges are also pointing to the fact that we as the judiciary are independent and as just as the executive and the legislature, that we can stand our ground. And this also is pointing to the fact that the judiciary is also coming of time and age that they can claim the authority independent, that they can make rulings and declarations that can go against even the person of the president. And Irene, when you look at this ruling, it has opened the president up for prosecution because the ruling stated that the president can be, or civil proceedings can be instituted against a sitting president. So it's not just about the current president, but also succeeding president. So unless that matter is reviewed to defeat the fact that the president can be prosecuted while still in office, then it has opened up the president for prosecution. And I think when you look at it from the integrity point of view, that the president can now be impeached. A Kenyan can move to Parliament and petition the National Assembly that the courts have found the president to have contravened Chapter 6 of the Kenyan Constitution, and therefore that threshold is enough to have the president impeached. So ruling has really opened up a lot of things to the person of the president, to the office of the president. Also, it has brought to limelight and to clear terms that this BBI process, as it is right now, it is actually trading on shaky grounds. And that when you look at the time between now and 2022 and what the courts are determining, then one would begin to worry as when exactly we should be able to hold this referendum. Because then when there are questions as to the legality and the constitutionalism of this referendum bill, then Irene, you will ask yourself, what if this Court of Appeal sets aside everything that the five bench of the High Court judges did? So will this process continue and when this matter is heard and determined? And what if again at the at the Court of Appeal that they agree with the ruling of the High Court? So that means we are going to the Supreme Court again with a second defeat. But then what if the Court of Appeal agrees with the Attorney General, agrees with Raila Odinga, agrees with others who are appealing this decision? That means the people who initiated this court petition will again take the battle to the Supreme Court. Yeah. And now we see another legal battle and tussle. So this is an interesting time, Irene, and we will be seeing as days unfold how these things will be working out.
All right. But looking into the ruling so far, do you foresee a situation whereby the Court of Appeal will be able to overturn the decision by the High Court? Looking into the way the five judges made their ruling, is there really hope for the process to move past the two courts, the Court of Appeal and the Supreme Court?
A very pertinent question there. And many legal experts are holding the view that it will be difficult for the Court of Appeal to overturn the High Court decision, because they say that the High Court did a thorough judicial and constitutional interpretation to arrive at this ruling. But then again, if the Court of Appeal will find that the judiciary or the High Court judges erred in their ruling, then they'll set aside the entire ruling and make something new. But then again, as I had said, it will open up another chance for the petitioners to go again to the Supreme Court. But going by what legal experts are saying, it is highly unlikely that the Court of Appeal will disagree with the High Court ruling. But then again, that is now upon the Court of Appeal judges to find if the High Court judges found merit in the applications, and if the appeal can be thrown out or be upheld. But as I had said as well, it is going to be an interesting time. But most importantly, the Court of Appeal, I believe in my mind, it's made up of superior judges, judges, of course, by judicial ranking are above the High Court. But then again, Irene, one thing that it's important to note is that the High Court of Kenya is a constitutional court. And therefore, whatever constitutional matter that sails through the High Court has to be examined with the thorough that it deserves. Because then again, when this matter goes for appeal and the Court of Appeal judges find that the High Court judges erred in their ruling or in their findings, or they missed key components or key interpretational clauses that would aid a proper ruling, then one would ask, why would the five-judge bench at the High Court make such an error? But then again, what if the Court of Appeal agrees with the High Court ruling? Then one can say 9 out of 10 that the High Court ruling will stand up to the Supreme Court. But now it is upon the parties going for appeal to convince judges of the Court of Appeal that we lost this case unfairly, and these are our grounds. And we want the decision of the High Court overturned on these grounds. So the burden of proof is on them. It is upon them to persuade the judges to make their case and tell the judges, look, this is the right thing for you to consider. Set aside the the High Court ruling and consider our plea. And then we also look at the issue of timeline, because initially we were looking at to go into a referendum by August, but now looking at the turn of events, and I really would want to remember that the High Court gave the IBC a permanent injunction, not just an injunction, but a permanent injunction, so that they do not undertake any activity as pertaining the Building Bridges Initiative process. So you'll understand about 21 declarations were made. So like making an application to set aside the entire declarations is also an uphill task, Karine. So they have to analyze which one carries more weight, which one should we deal with at the Court of Appeal. And Irene, one thing I would want to underscore is the fact that the president is yet to appoint judges to the Court of Appeal. And legal experts say the Court of Appeal needs at least 30 judges. Right now, they are about 11, because now Lady Justice Martha Koome, who is, of course, going to be the next Chief Justice, and now Justice Ouko, who is now a justice at the Supreme Court. You'll understand and appreciate, Irene, that the Supreme Court, the Court of Appeal, is starved of judges. So there is a lot of work already in the Court of Appeal, and if we had enough judges, then this also would be an issue of, okay, fine, we have enough judges who can handle this case. But then Irene, the judiciary feels that the executive is muzzling it out, and there is that visible animosity and tension between these two arms of government. So what if, again, there is that sort of tension that of course can potentially like carry itself into the Court of Appeal. So those are some of the things that experts are looking at and saying, well, Attorney General Kihara Kariuki is taking this appeal to a court that he should have advised the president to appoint judges that are already suitable, and those who are like the president still has a doubt in their integrity, then, because if we have three whose integrity the president is finding possible to question, then what if the president could have appointed the rest? Because again, it is about facilitating justice. It is about ensuring that the judiciary is well staffed to deliver justice to Kenyans, so that
Mr. Kigoli, let me cut you short there. Still on that note, there has been the question, now that you've mentioned Attorney General Kihara Kariuki, there has been a question that the president does not have enough, or is lacking in terms of legal advices looking into the declaration that was made by the High Court concerning the president violating the Constitution. Do you think President Uhuru Kenyatta has lacked legal advices and the Attorney General Kihara Kariuki has failed, in a nutshell, as you conclude the interview?
Well, you see, there are different scenarios to this simple question. Number one, Irene, is that the Attorney General could be advising the president, and the president is at liberty to take in advice or decline. The Attorney General could be misadvising the president. The Attorney General might not be advising the president correctly. So we do not know, because then again, we never voted for an Attorney General, we voted for the president. So perhaps it is upon the president to, decide which way to go. Like, Attorney General is just an advisor, a legal advisor to the president. So the president is at liberty to choose, like, if he's going to take in the advice of the Attorney General or not. But then again, it will impact on the presidential judicial scorecard. Many Kenyans will ask years from now, how did President Uhuru Kenyatta fare as president when it comes to legal matters? And many experts have been pointing to the fact that the president doesn't have a good score when it's a matter touching on the administration of justice or facilitating justice. Because understand this issue of revisiting. You'll understand this issue of like, what is the president doing to make sure that judiciary is functioning well? So Irene, it's an interesting question that you posed. It's simple and interesting, and it's also opening up discussion to, is justice a matter of personal choice or it's a matter of public interest? And I would appeal to the president to, as I wind up, to ensure that Kenyans are given justice, and that includes appointing judges to our court so that they are not understaffed and justice is not delayed by lack of judges.
All right. Thank you so much, Mr. Kigoli, for making time and giving us a perspective. Of course, we are pressed on time, unfortunately, but it is a discussion that will continue to build momentum as we go. Many thanks indeed.
Thank you.
All right, that has been Mr. Edwin Kigoli, a political analyst, giving us his perspective concerning the BBI ruling. We are taking a short break. We'll be back with more on what is happening in the world of sports.